While getting it, I was informed even appellant number 1 has also passed away, but
Mr. D.K. Bhattacharya, Learned Counsel for the petitioner, on instructions has submitted that the appellants in the present proceedings are no more in the world. Have passed on during the pendency of the present. He submits that he has the death certificate of the appellant number 2, Narayan Sharma, who had passed away on 7/5/2021. However, the date of death of the appellant number 1 is not known to him. So, in view of the above, Mr. M.P. Goswami, learned. Mr. Goswami, you will do it? Goswami submits that he would receive instructions the matter as to whether the appellant number 1 has in fact passed away during the pendency of the present. He prays that the matter be listed on when? On 23/9/2025. So accordingly, a registry to list this matter came on 24/5/2025. 24/9, sorry.
obliged.
I was with this 5.
Kept on record.
Next day.
Please.
You have circulated a memo. Item number 15. A prayer is made on behalf of Mr. Bothagur for an adjournment in the matter on the ground that of personal inconvenience. Prayer is not objected to by the Learned Counsel for respondents. Accordingly, the registry to list this matter again after 2 weeks on a date to be fixed by it. Yes, ma'am. 19. Of file to sir. Raise it before this court. Yes. B. A prayer is made on behalf of Mr. J. Chutia, Learned Standing Counsel, KAAC, hearing for the respondents number. The respondents number 3, 5, and 6 for an adjournment in the matter on account of personal inconvenience. Prayer is not objected to by the Learned Counsel for the petition. So accordingly, a registry to list this on a date to be fixed by it. Matter will not be considered as a tied up and/or as a parted and/or tied up matter with this bench any further.
I beg to mention
that you will have to go before the senior bench. 7. Sorry, rejected. Be here when the matter is called up. It's a revision matter. That railway matter. We can't help it. These matters, no adjournment. Mr. Sattar, we had required your junior to do the matter. Anyway.
Yes, my lord. Equally competent, but
she had taken this court. She had stopped this court from proceeding with the matter on that day. We were ready to dismiss the matter on that day. Okay. No, you argue. It's okay. Please, Mr. Sattar, please take over. Now, better in
Sorry, my
another
lord.
case, we'll hear her. No, it's okay. It's okay, Mr. Sada. There is no issue.
My lord, the FIR in fact was filed on, my lord, 23/8/2000.
Mr. Sattar, this is a revision petition
Petition, yes.
with regard to concurrent findings. So you know our limitation here.
My lord, here, what I would like to submit before your lordship,
Hmm.
that conviction is made on the basis of presumption, my lord. And moreover, my lord, the very material witness, according to Mr. Gurung, was the domestic aid, was not examined.
That
not
was
examined.
considered
Who
by
could have
both
been
the,
best
that was
witness.
considered by both the trial court as well as the appellate court.
But my lord,
What is the error?
I am placing before your lordship that
Tatar, one issue before you, just to disclose my mind. The evidence of the victim, Gurung, is direct. Is direct.
but nobody has seen that.
And where is the requirement? You have not disclosed that.
My
And the
lord,
and the other three witnesses who were not eyewitnesses, but they have said about the occasioning of that incident. That halla there,
yes,
that thing, everything. And this man, he was only a CRPF personnel. He had got nothing to do with the traffic management duties.
but
And see, the evidence is also to the effect that your superiors
my lord,
had
taken him to the hospital.
everything. They had apologized. They had taken him. You could have brought them as defense witnesses. You have not even brought them as defense witnesses.
My lord, they were my superiors. How
What
can I react?
departmental proceeding did you undergo here?
My lord, I was
That again goes to establish the fact.
my lord, had the prosecution been in a position to even summon these persons, my lord, then they would have been the best witness. So
We are not concerned with that. We are not concerned with the quality, with the quantity of the witnesses. We are concerned with the quality. And we find that the PW1 who had deposed, there is nothing to disbelieve him here. Now you can proceed.
my lord, may I take your lordship to
Second use. Record.
these under section 3?
Voluntary cause hurt here is without any provocation you have hurt him.
Lord, he himself has admitted that I had parked my vehicle.
Fine, but that does not mean that you have the liberty to bash up anybody.
No,
That
no,
too. You are only to assist the state authorities. And these things we cannot accept. Okay, what do you want me to look
My
at?
lord, that cross-examination part of Mr.
Hmm.
is appearing at page number 3.
Hmm.
Handwritten, my lord.
Hmm.
I retired from service in the year 1988. I have not been provided with or Ardali Peon after retirement. I have two sons. One is retired. I am skipping that, my lord, about the family. I used to visit Machkwa market to purchase. Jan Bazar market is nearer to me, and in that market is also available vegetables are found. I always take the domestic help with me, but I could not name him. When I was in the Machkwa market, 17/8/2007, the domestic help was with me. My lord, here, as your lordship out regarding his person who is the domestic help, my lord, not known to the person himself to whom he has taken to the market. And domestic help would have
How
been
does it reduce the value of this evidence? That statement.
beating and everything concerned, my lord, I will come to. Nobody has seen that. Nobody has.
Okay.
I always take the domestic help with me, but I could not name him. When I was in Machkwa market on 17/8/2007, the domestic help was with me. I am not occupied with not I am not, no. Accepted with the Machkhwa vegetable market and about its boundary. I parked the vehicle on the HB road. Normally, I used to visit the market once a week. Or at the time parking my vehicle, neither there was traffic police nor there was CRPF personnel. I was not
Aware.
aware, and after the I was
Bomb
not
blast.
aware after the bomb blast, Machkhwa vegetable market was declared as sensitive area and so and so. So this from sensitive area.
He committed a traffic violation, guarantee.
Violation.
Understood.
That was restrained. So far the beating is concerned, my lord, nobody has. I did not ask to the assistant commandant of the CRPF, namely Sher Singh and Rao
Rao.
Patil, about the duty of checking the vehicles by the CRPF personnel. I know that an FIR was filed against me, but police has not inquired about the case. It is not a fact that at about 11:30, the accused has shown his intention to check my vehicle, to which I reacted, and I did not allow him, saying that I am a retired IAS officer.
So this suggestion was denied by him.
Yes, this suggestion was denied. But there was an FIR by the police against him.
Against the 40 traffic violation.
Traffic violation, yes. Traffic was violated, that is there, my lord.
So no issue on that.
So, my lord, it cannot be said that it was voluntarily causing harm.
No, you please go ahead.
It is
It is
not,
not.
it is not a fact that I started beating the accused first. It is not a fact that while I started beating and then in defense the accused tried
Raised.
raised his lathi, by which I got injury over my left arm. During my presence at the spot and parked vehicle, neither any police nor any CRPS officer came to the said spot. I have not named any person seeing me in beating by the accused person. I lodged the FIR at Panbazar police station. I was not hospitalized at any hospital from 17/8/2007 to 23/8/2007. I have not submitted any admit card before the IO. It is not a fact that as Mr. Tiwari was to search my vehicle and that hit my ego and therefore lodged a false FIR against him. I have not given to the IO any about the consumption of medicine by me. I can recognize AC Singh and Mehboob Alam only spoke to me over phone. It is not a fact that I lost the FIR with a complete
Cooked up story.
cooked up story. It is a fact that I told the accused that CRPF personnel like you polished my shoes. My lord, whosoever he believed that they have taken the hospital, they were the two persons, Mr. AC Singh and Alam. But my lord, he had only talked to them over phone. But
He
in the
was
FIR
taken
he
to
has
hospital
in the
by
FIR
that Rao Patil and somebody, one more.
my lord, Rao Patil and
And Sher Singh.
Sher Singh.
Mm.
Sher Singh.
They are the ones who took him to the hospital. The commandant calls up, he was taken to the your center group hospital.
That
Group
is
center.
the story, but they have not.
Fine,
been examined.
that's not required. We are only required to look in whether there was an assault made by you
Yeah.
on him. And that material is very much here.
My lord, so far the claimed eyewitnesses are concerned. That is PW2,
They are not claimed eyewitnesses. They have not seen the incident. They have
but police have
only seen the halla
yes,
and
my lord,
that gathering there.
yeah, but
to
the
that
police have
extent.
examined.
Please examine them, but
Examine them.
their evidence is only to that effect.
Yes, so Babu Ali and Ram Babu Shah and the Kupal Das, they have said that they have not seen the occurrence. my
They
lord.
have not
Simply
seen.
they came, they were serving in some hotel, came outside and they saw that there is a gathering, my lord. Nobody has seen that I have ever beaten the.
Because it's after you gave him a blow, and naturally he is a
My lord, seeing,
CRPF personnel. People will also be afraid to come forward.
my lord, seeing of the blow, nobody has seen. The blow has nobody has seen. Now I am taking your lordship to the doctor's examination.
That is important, the cross part. Because that will establish that you were taken there by CRPF personnel.
That he says that I was taken. He says
That
yes.
is not least, that is in cross only.
Yes.
Mm.
PW4, my lord. All the other witnesses, they have said that. we
Okay,
have
other
not seen-
witnesses are not relevant. Can you read that page 2?
Yes, my lord, the cross-examination part.
Injuries are there. We can
Okay,
look.
injuries are there. So should I read the whole, my lord?
And if you want, you can. If you want to highlight something, you can. Otherwise, the cross will do.
On 17/8/07, I was working at MMCH as deputy superintendent. On that day, I examined Mr. KB Gurung, aged 65 years, accompanied by some CRPF personnel at 12:20 p.m. On examination, I found the following injuries. Multiple contusion on the left arm in its lateral aspects over an area of 10 cm into 5 cm. Contusion on the forearm in its lower third, size being 5 cm, 2 cm, along with a laceration of 1 cm into 5 cm on the lower lower third arm of the forearm. Now, my lord, X-ray was advised for the left arm, forearm, and X-ray plate number 4708 reveals fracture of both the bone of left forearm in its left forearm. Inference was, my lord, injury number 1 was simple and injury number 2 was grievous. Both were fresh injuries and caused by hard and blunt object. The patient was referred to the orthopedic surgeon on the same day. Exhibit 2 is my report and 2. Now, my lord, since 1994, I have been serving at MMCH. Letter pad has been provided only to the superintendent. Orthopedic department is present at MMCH. The patient was not referred by police, but he attended himself.
Go ahead.
Accompanied by the same CRPF personnel.
Some CRPF personnel.
Okay, some CRPF personnel. I have submitted the report on 12/10/2007. I have prepared Exhibit 2 on the basis of my OPD register. I have not mentioned in my report the OPD number. X-ray plate is not available on the record. I have not remembered if I received any report from orthopedic department from 17/8/2007 to 12/10/2007. This goes on to show, my lord, that when the very X-ray plate was not there before, how he can say that there was lacerated wound or some wound.
Lacerated wound is by the eyesight, not it's a outside wound.
But-
It's not the X-ray is only for the fracture, which is inside.
Yes, that is inside.
But the lacerated wound will be on the arm. It will be on the eyesight.
Yes, my lord, that is there, but my lord, so far the X-ray plate is concerned, that will only say
Because
that
if
there is,
that fracture part,
yes,
fracture part,
yes.
you go ahead.
I have examined the X-ray plate on 17/8/2007. My lord, I am taking your lordship to.
It is unlikely to get such injury with laceration and contusion by falling on hard substance.
My lord, X-ray plate is not available on the record. That part. X-ray plate is not available on the record. I have not remembered if I received any report from orthopedic department from 12/10/2007. I have examined the X-ray plate on 17/8/2007. Likely to get such injury with laceration and contusion by falling on a hard substance. I have not.
Not remember as to
remembered
whether.
as to whether the patient has told me about the hard blunt object or not, but he came with the history of assault. X-ray was taken on the same day. I have not mentioned in my report the date of X-ray plate. As I remembered, I issued the report to the party. I have provided him treatment. I have provided him treatment, not the fact that exhibit 2 is a manipulation.
So here, only to the extent, this is an opinion, only to the extent that he had received injuries
Injury.
by way of a blunt object, that is clear. Now, if we superimpose this with PW1 and the deposition therein of his attack, you making an attack on him, this corroborates.
My lord, I have not made any attack.
That is your stand. We'll consider. Then what?
Thereafter, my lord, so far the PW5 and other witnesses are concerned, they have already said that I have not seen the report.
And that's true. And in 313,
Matter was investigated by my lord, Festar police station.
then they realized that it is not our jurisdiction, so they
Then
transferred
sent
it
to the
to,
Honorable Mukhlis.
then they took the matter forward. Now, here in your 313, there is no explanation other than just denial.
But my lord, nobody has seen that I have ever beaten him. They said even a
What
single
is the
word.
position of law, Mr. Sattar, with regard to a victim evidence? Supreme Court decisions are galore on that
My
it
lord,
can be relied, if not inconsistent.
There might be some tussle. Person was holding the position head officer. He must have thought that I will give you a lesson, and he has
Demonstrate that from your material. Even in 313, you have not said so.
No, my lord, that I have already taken from his mouth. PW1,
Huh?
PW1, last line, my lord.
Huh.
That I will give you a lesson.
That is just a suggestion. Where is your explanation in 313 that say these incidents did not happen? I asked him to move. See, logical thing. I asked him to move. Then he started showing off that he is an IAS officer. He will get with me, and that's a false case.
That
Yes.
generally happens, my lord.
But for this court to understand, to visualize, it has to be brought here. I don't have that sixth sense. No.
But in the 313 statement, my lord,
No, he should have given at least a clarification. 313 is only not to say that not admitted, not
I have
admitted,
not
not admitted.
committed any offense.
That's what
Yes.
they do. The mistake is there. If they had given a clarification there, that would have had some value. We would have required to consider that. That what you said now, if there was a line to that effect there, enough.
That line is not there, my.
I'm sorry, we went through it. Anything more?
Its only thing is that there is no explanation as to why the delay was 28 and that is filed on 23. There is no explanation.
That is not a ground to.
Moreover, my lord, some 18 years have already been.
Yes, 18 years. How does it undermine the offense?
So there is no offense, my lord, but in fighting out the litigation, 18 years have been.
So what do you expect from this court? Conviction, we are not touching. Anything to do
Any
with this?
leniency from the honorable.
No, leniency. I want it from you. Tell me what
My
leniency.
lord, rigorous imprisonment for one,
Uh,
5,000 fine.
it is 325. It is along with fine. That statement from you, how we can help you? And shall also be liable to fine. So it's together.
Yeah, that is there, my lord.
You tell me how we can help you.
But,
Okay, we'll hear Mr. Borua. Yes, Mr. Borua. Mr.
Just
Sattar
waiting.
will formulate his arguments with that. Till that time, we'll hear you.
Evidence part Lordship is yes, sir, is defined under
This incident is of
2007, my lord.
Effects are my lord as per doctor report.
Mr. Borua, the man has already lost his job. He was litigating in the trial court, then before the appellate court, now before this court. In the meantime, 10, 15, 18 years have passed by. Right? We maintain the conviction subject to what Mr. Hum says. We maintain the conviction. We give him the probation of offenders. That's what I wanted from Mr. Sattar.
This person, my lord, he sought the circumstances, my lord.
He
was
has
taken to the
he has
hospital, my lord.
suffered for that act of his.
Yes,
He has already suffered. He is in his house now without pension and all. So let him not be, he'll be now around maybe how much, 60, 70? 70 years. I will not go into that.
9% may be increased.
We will, no, I will not do that. We will only say that the sentencing, jail sentencing, it would be under that probation 4. We give him that benefit. He will execute a bond here. That is also would be a trouble for him because he'll have to come from there here to execute that bond. If he doesn't execute, then the jail term would be there.
Subject to his, I mean,
No, it's okay. We don't know that, so we'll not
anyway,
go
my
into
lord,
that.
I will do.
We'll not go into that. We are giving him probation.
that.
Let us give this matter a closure. Disposed of, huh? You say that it should be maintained. You both, you and Mr. Alam will say that, huh?
There is
Appel.
no wrong in the
No, we'll not put it in your mouth. We'll put it in ourselves only. We'll do that. We'll say both of you have vehemently objected to that. We'll get it in a day or two.
My lord, my lord.
Next.
Item 2.
Yes, madam.
This is for 2009. Section 326. $1,000 and in default.
What is the condition of the victim now?
My lord,
Condition of the victim, any idea? Condition of the victim, any idea? No. You are married now.
yes, I have 2 kids. 5 days I am behind the bar.
But madam, the Supreme Court decisions with regard to acid attacks. Supreme Court says that this is very serious thing. The exemplary punishment must be given. Here the gender has changed, but the law will remain the same.
But my lord, it is not. Look at
There
that,
is
my lord.
there is enough proof
Enough.
of at least two
Only-
witnesses.
A criminal case, different angles, my
Madam, will somebody go and pour it on his own face?
a criminal case must different angles, my lord. It is clear-cut case, my lord. Only the two persons said that we have seen the victim, sorry, the accused, and both are brothers. So there two one.
See, at
They
that
are
point of
interested-
time,
Interested witness, and there is animosity, which is already proved. There evidence it is that a case has been registered by the
but see, ma'am, but the problem is neither before the trial court nor before this court even today. What is that case? Nobody has disclosed. It's only a projection that an FIR was placed and a case is pending. Neither the FIR was produced as an exhibit by you. You had defense witnesses coming on record. Nothing, nor in the appeal, this was given. So that aspect, we don't know what it is. What is that effect? And the only
It is
statement,
also not proved that that was an acid attack.
Madam-
That was
Madam-
also not proved.
Madam, here the only thing that is proved is that you had gone to the house of the victim, proposing a marriage. The elder
Before my lord.
brother had chased you out, which led to an FIR filing.
Yes, yes.
That is the material. If
And
that
he-
be
he-
so, how can there be an
My
incident
lord, his elder brother was also convicted, my lord.
in that case?
Yes, my lord. During the. And his brother also said that, and the elder brother also admitted that a case was pending at that time, my lord. During
And that is there.
there is any animosity is there, interested, they are interested witness, my lord. The acid attack was not proved. Where from the acid is collected, it was also not proved. The glass from by which she poured the acid, that was also not seized, my lord.
Madam,
Most part of my
madam,
lord,
those
lord.
things,
No, my lord, the MO's part is very important in a criminal case, my lord. MO's kinds of the MO, my lord.
just a second. So it was a love affair gone sour. Well, the person was acquitted. Now, madam, things will get serious. This judgment is before the attack. Before the
No, my lord.
attack is on.
It is on my lord 24/4/2009, my lord.
Yes.
Time proceeding was going on, my lord.
What is yours? No, now I have got mine. You can continue in your own way.
My lord, kindly
FR,
FIR.
FIR. Is it on record here? No.
It is there.
Yes. Yes, ma'am.
May I- এইটো
The FIR was here, but and that is it. Earlier, there was no system of indexing and all. It was to just come. I found the FIR that day.
Give me my little file.
Actually, yeah. FIR was lodged by the brother.
অৰ্ডাৰ কেইটাৰ পিছত এইখন অসমীয়া পেকেটা মাৰি দিওঁ ৰ'ব।
Got it?
Yes, yes.
সন্মানপূৰ্বক বিনীত।
আজি তাৰিখ 24
বজাত।
পখলি 50 বজাৰত থকা অৱস্থাত সাতপখলি গাঁৱৰে শ্ৰী হীৰা পিতা ফুলা হীৰা এণ্ড প্ৰফুল্ল হীৰা পিতা লৈ আহি ঢালি দৌৰি পলাই যায় আৰু লগে লগে পৰি যায় আৰু তাতে মাছখিনি থকা এচিড পৰি আহত হয়। মোৰ ককাইদেউ সাংঘাতিক ধৰণে আহত 108 এম্বুলেন্সখন মাতি আনি গুৱাহাটী মেডিকেল লোককেইজনে মোৰ ককাইদেউৰ হাতত থকা মোবাইল ফোনটো লৈ যায়।
জিতেন হীৰা।
And he is the elder.
Hokkaido, he is the younger brother.
Sorry, my lord, the younger.
Okay. Outpost. Then they made a GD entry.
Yes. Ten PWs, one CW, the uh, evidence of PW1, my lord. Yeah.
Yeah.
I filed an Azhar whereby exhibit 1 is my signature. My elder or younger brothers when accused Mirahira assaulted me, the result of which my younger brother say Robin Hira came to me. Hearing about the incident, I rushed to the place of occurrence and there an ambulance was called upon. Accordingly, my said brother, I did not stay with my said brother. Thereafter, next day morning, I in connection with the and my said brother unsold and also he also lost his mobile. Word me stated has not been police personnel cannot recollect as to whether the policeman said FIR as the instance of the Azhar which was written FIR my person said Montu Das and occurred. I wrote the next day, the incident, next day of the incident, it was not a fact that filed by me is not a misfile on the one from my said brother. Accused Mirahira assaulted my brother as grudge. For that incident, one day at a accused Mirahira came to our house, desire to live in our. Then I ousted Mira. At this, Mirahira had beaten my brother. There was no love. Mirahira also lost an Azhar for this incident pending trial in the court. It that we in the case filed by Mirahira against us previously. It's the fact that prior to the incident, there was illicit relationship. Mirahira and my brother. The fact, on the day of incident, my sister tried to enter the house of Mirahira with tension and seeing some other persons is assaulted my brother, so that the accused Mirahira did not saw smokes coming out of the said liquid. Realized that the said liquid was then, but I heard about the incident. The fact that due to gas grudge, we detected the accused Mira. The evidence of the W1. According to him, accompanied by
Five
other,
brother, four others. But the trial
they
court,
are altogether 5 persons.
the brother also said he saw the brother and Meera. The brother of the victim said he saw Meera and Pradeep. Others have not been there,
But
but the other persons who were there in the village have not said.
Who was present at the time of
Nearly
incident. That
sitting
is
with the,
my lord Robin Hira. But cross my in evidence, my lord. Now, my lord, see.
W2.
PW1 is not a witness. He was there, my lord. It is clear, my lord. And there is a case is at that time case was going on
It was against him also.
against him, my lord. W2.
But in that case, the victim was acquitted. The victim here, in the earlier
Yes,
case, he was
he
acquitted.
executed, but because, my lord, that brother
Did something. 323.
assaulted her, my lord.
323.
W2, elder brother. The incident took place on 24/4/2000 at about 6:30 time. I was selling in our same shop. And came with a glass of liquid. Liquid over the face of my brother. Others, namely Tom Das, who came to our shop for purchase of fish, were also injured. The fish fell down and I went to my residence. Then Hira, PW1, about the then to GMCH Guwahati for his treatment. Go with him, the GMCH. Accused Mirahira ran away from the place of occurrence after Mirahira came to the place of occurrence along with a boy. According to him, he came with a boy. I do not know the name of the state boy. Wage earner and work. I have not recorded my statement. Mirahira came to the place of occurrence wearing a suridar, covering her head with a face and poured the said liquid. Then I was very. Mirahira poured the liquid on. Accused Mirahira came there on foot and was brought in a. I do not know. I heard that one day Mirahira came to my residence. Or house or not. I do not know anything about any matter. I heard that my brother Jiten Hira had been beaten by accused Mirahira. At that time, I was not present. I was present at the time for the seat on came to know that liquid was burned the clothes.
Madam, we have gone through the evidences of PW1, PW2, because he is the only eyewitness who has identified the appellant. Now, one thing, if you go through here, you also had taken a plea of alibi. Huh? There is nothing brought on record, crossed here, that your presence there was improbable. There is no
Yes,
question.
improbable, my lord.
No. To the,
Because, my lord, other witnesses.
we are trying to
those are-
recreate this
Sorry.
crime scene. Here, when you are crossing that witness who says that he has identified you, you have not even put a suggestion that that was improbable because you were not there. There is no suggestion even to that effect. The plea that you have subsequently taken in your defense, that you were in your sister's house and had proceeded there with your brother-in-law. This suggestion, even a suggestion is not there given to the PW2 that you are making a false statement because I was not here only. Foundation is not there, right or wrong. Nothing is here.
Yes, there are two eyewitnesses.
Cannot
Other
be.
independent witnesses.
Cannot be.
No one has said that Mira was present or a lady was present.
No, lady presence is there.
My
A
lord,
lady's presence is there with that the person who was a customer.
she lives from the, my lord, this place of occasion only 1 kilometer, my lord. Everybody knows each other in a village area, my lord.
Madam, that
Nobody says that she is Mira.
she had covered her face with a scarf and she had come. Now
If
that
she
is
comes with
improbable.
her family, then everybody will, my lord, and
That
somebody
may be
will
an
try to
exaggeration.
nab her, my lord.
That may be an exaggeration rightly taken care
My lord, if she had committed the crime, somebody will try to nab her, my lord,
of.
the place of occurrence.
Lady, that
Even
would
my lord, the court witness also said that I did not.
cannot be because the victim is sitting like this, selling. Customer is buying. The material is that she came and poured. So this man, it was poured from his backside. She came from his backside. So it is natural that he will not see her.
What you will say, my lord? It is a marketplace, my lord. It is not a house, my lord. The presence of before the 2 or 3 persons, my lord. Marketplace, my lord. In the choke, my lord.
And see, this incidents happen, then there is a concentration on the victim, not on the aggressor. By the time she was a lady, if he was a gent, maybe somebody would have caught him also. Lady, she moved away immediately.
Evening,
No, my
Evening
lord.
time, it was just dusk. It was getting darker.
yes, 6:30.
And there is a statement also that although he had lit his lamp, it was not dark till then. The victim statement is there.
Generally, my lord, in village area, my lord, my lord,
Saki, they put it.
Arten,
they no,
No, that glass lamp.
glass lamp,
Glass
my lord. Kerosene.
Anything move. Till now, nothing.
Now, my lord, I go to the medical witness.
Before that, Sushil Hira, this is that victim.
Statement is there, my lord.
He has done it. PW6, yes,
W6 is the, my lord, medical witness. Medical MO, my lord.
doctor.
Last 28/8/9, I was serving register of Zari probably.
And this man had not examined him. He is only making this statement from the records.
Record of the case. So, my lord, may I read the cross portion?
I did not examine this at witness personally. I could not say the injury.
What injury was sustained by the patient? I could not examine the patient.
Just seeing the hospital. I am
Hospital record. The report with a serious case, but on who examined the patient, he was not.
But that statement from the last line of the course examination, he made that deposition from the records. And
May be true or may not be true, my lord. But the person
But-
who
but-
examined the person, my lord,
problem is,
who examined the person, he must be examined, my
Madam,
lord.
the problem is,
He has to establish the crime, my lord.
madam, the problem is not even a suggestion to him. Let us come to your 313.
But it is not. Moreover, my lord, in the
Only,
and also
only,
there was
only,
no
only,
discussion
only,
about 313, my lord.
only denial, nothing, no explanation.
The defense witness, some witness should have the Arnett court below, my lord.
Understand? That is why I asked you.
But
Where
that
is
is
your
the-
foundation when
That might
crossing?
really be that on that day I was not present there. I was somewhere else. And it is supported by other witnesses also, my lord.
Madam,
Furthermore, my lord,
that statement of yours to be taken, the foundation should have been brought while you were crossing at least the victim and PW2.
my another some for 45 days.
PW4. PW4. Siddesh Sodas.
Yes, sir, does.
I know Sushil Hira. So and so, I came to
Nine at about 6 o'clock to purchase fish. Then I was present in the shop of others were also present in the shop of Susil. So there are other person also. Only that person that W4. When I was bargaining with on the price of the fish, accused person came there with Suridar by covering her face with Sunni eyes and pour some liquid on the face of Susil Hira.
some portion.
Portion of the said liquid was also fallen on my long. The result of which my long pen was burned, which was taken by police. The result of the incident, there was Halla Susil.
As the person,
Hmm.
I only saw pouring because he was
And one more. MR was not exhibited before the court.
legal report
My lord,
recovered.
recovered, my lord. Those were not exhibited. Point, my lord. Come to the deposition of W number, my 9. Submitted the search sheet.
D. Mohan
Medini
Bro-
Mohan Baruti.
Medini. Yeah. Just a bit, sir.
25/2009 তাৰিখে জয়নগৰ থানাত আইচি হিচাপে কাম কৰি আছিলো। সেইদিনা মই জিতেন হীৰাৰ পৰা এখন এজাহাৰ পাই ASI শ্ৰী অশোক কুমাৰ প্ৰাথমিক তদন্তৰ এক উক্ত এজাহাৰ কৰি মোক ডায়েৰী সমজাই দিয়ে। মই গোচৰৰ পঢ়ি চাই গোচৰ সুপ্ৰতিষ্ঠিত হোৱাত আছামী শ্ৰী মীৰা হীৰা, দেন হীৰা, ভাৰতীয় দণ্ডবিধি আইনৰ 147/26/307 পত্ৰ দাখিল
তিনি
অভিযোগনামা চাৰ্জশ্বিট।
Fine. Cross.
মই এই গোচৰৰ কোনো তদন্ত কৰা নাই আৰু সাক্ষীবাদীকো সোধপোছ কৰা নাই।
Because he is only filing the
Person who
PW10.
Ashok Kumar Singh, W10. তো 25/4/2009 জয়নগৰ আউটপোষ্টত অফিচাৰ হিচাপে আছিলো। মোক সেইদিনা আইচি মেদিনী বাৰুতি দিয়া মোক প্ৰাথমিক তদন্তৰ ভাৰ দিয়ে। গোচৰীয়া জিতেন হীৰাক মই থানাতে সোধপোছ কৰোঁ আৰু সেইদিনাই ঘটনাস্থলী সাতপখলি বজাৰলৈ পৰিদৰ্শন কৰোঁ। মই ঘটনাত স্থানীয় সাক্ষীবাদীৰ জবানবন্দী লওঁ। ঘটনাস্থলীলৈ গম পাওঁ যে সুশীল হীৰাই 24/4/2009 তাৰিখে বজাৰত মাছ বিক্ৰী কৰি থাকোঁতে মীৰা হীৰা আৰু প্ৰফুল্ল হীৰাই গৈ মীৰা হীৰা গিলাচত তাৰ মূৰত ঢালি দিয়ে।
দলীয়া বস্তু
ৰেড মাইল।
দলীয়া বস্তু লৈ
ৰতন ঠাকুৰীয়া নামৰ এজন গ্ৰাহকে তেওঁৰ ওচৰত মাছ কিনিবলৈ যাওঁতে উক্ত পানীয় বস্তুখিনি তেওঁৰ গাতো পৰে। আৰু উত্তম
এইটো জন।
ঠাকুৰীয়া দুয়োজনে জখম পায়।
whether it is law, no, po, very difficult to read.
Difficult to read.
It will be Punya.
Find it difficult, though we are from Assamese, my lord. পানীয়খিনি এচিড আছিল। সেইদিনা ঘটনাস্থলীত সকলো ৰাইজে জখমী দুজনৰ এখন এম্বুলেন্সত GMCH-লৈ পঠাই দিয়ে। মই GMCH-লৈ গৈছিলোঁ, কিন্তু জখমী বেয়া দেখি তেখেতৰ জবানবন্দী হস্পিটেলত তেওঁৰ ঘৰলৈ আহোঁতে 4/11/2009 তাৰিখে জবানবন্দী লিপিবদ্ধ কৰোঁ। মই উত্তম হীৰাৰ জবানবন্দীও তেওঁৰ ঘৰতেই লওঁ। মই জখমীৰ মেডিকেল ৰিপৰ্ট সংগ্ৰহ কৰোঁ। সুশীল হীৰাৰ জখম হৈছিল। মীৰা হীৰা আৰু প্ৰফুল্ল হীৰা পলাই থকা বাবে প্ৰথমে পৰা নাছিলো। পিছত 29/9 গ্ৰেপ্তাৰ কৰি আদালতলৈ প্ৰেৰণ কৰোঁ। তাৰপিছত মই এই গোচৰৰ তদন্ত কৰি গোচৰৰ দিওঁ। ঘটনাৰ পিছদিনা মই ঘটনাস্থলীলৈ যাওঁ। মই ঘটনাস্থলীলৈ গৈ কোনো বস্তু সংগ্ৰহ কৰা নাই। মই ঘটনাস্থলীত সাক্ষী কেইজনৰ সাক্ষী লৈছিলোঁ। দুজনমান সাক্ষীয়ে কোৱা মতে আসামীক বিচাৰি গৈছিলোঁ। মই দুজন আসামীৰ বিৰুদ্ধে কেৱল সাক্ষীবাদী চাই গোচৰৰ প্ৰমাণ পাইছিলোঁ। জখমী সুশীল হীৰাৰ জবানবন্দী তেখেতৰ ঘৰত 4/11/2009 তাৰিখে লৈছিলোঁ। তেখেতৰ তেতিয়া চিকিৎসা চলি আছিল। যিহেতু জখমীৰ মুখখন জ্বলি গৈছিল আৰু ডাক্তৰেও পৰীক্ষা কৰি এচিড বুলি কৈছিল, সেইকাৰণে মই এচিড ঢলা বুলি কৈছোঁ। Try to check that whether that substance is acid or
He did not
hot
get
water.
the substance. He did not get the substance.
Try to even
That glass was not there.
collect something from the place of occurrence, my lord. He self-stated.
Okay. Moi, come to court
That means,
witness one.
that means on the basis of others, he stated like this.
Okay.
Plus, W is also, my lord. W1, my
From
lord.
Thakuria.
ওচৰৰ সাক্ষী মীৰা হীৰা, প্ৰফুল্ল হীৰা, বীৰেন হীৰা, মইনা হীৰা আৰু ভোলা হীৰাক চিনো। মই জিতেন হীৰাকো চিনো। মই
Sinu.
আজিৰ পৰা
He was all.
বছৰৰ 6 আগতে ঘটনা হয়। ঘটনাৰ দিনা গধূলি বজাৰ চকত হোৱা থকা সুশীল হীৰাৰ দোকানত মই মাছ চাই থাকোঁতে কোনোবাই সুশীলৰ দোকানলৈ বুলি এচিড মাৰি দিয়ে। তেতিয়া সুশীলৰ মুখত পৰি মুখত জখম হয়। মোৰ হাতত আৰু ভৰিত জখম হয়। বজাৰত বহুত মানুহ আছিল। কোনে এচিড মাৰিলে মই দেখা নাই, ঘটনা দেখা। The DWs, 4 DWs are there.
We have seen that DWs. They basically is with regard to that especially that lady who had come there to buy a pot. She has said that you were not there. You had gone to the house of your sister.
Yes.
That's basically the thing. Fine.
The DW4, my lord.
We have seen that. Okay, what are your submissions now?
That the case is based on that witness is there, my lord. Because they are both
False story.
will support the. They have animosity also there. It is also, my lord, established from the evidence of the victim also, my lord. He also stated, my lord. Okay, my lord.
Leader.
Right, my lord. I want
Still. Hmm.
in the cross, my lord, it is established.
Hmm.
May I read?
Yeah, ঘটনা 24
24/29 ইং তাৰিখে হৈছিল। সময় আছিল 6:30
মানত।
তেতিয়া সম্পূৰ্ণ অধ্যয়ন হোৱা নাছিল আৰু মই চাকি জ্বলাই দিলো। ঘটনাৰ প্ৰায় 10 মিনিট মান পাছত জ্বলাই দিলো। এগেইন মোৰ দোকান খোলা ঠাইত, সেই ঠাইত সদায় মই দোকান কৰো। যিদিনা আছিলো মোৰ ভাইটি আছিল আৰু সিদিনা মাছত তেতিয়া মোৰ কাষ্টমাৰ সিদ্ধেশ্বৰ দাস আছিল। সিদ্ধেশ্বৰ দাসৰ ঘৰ মিঠাহীৰা চুৰিদাৰ পিন্ধি আহিছিল আৰু চাৰ্ট ৰঙৰ পিন্ধি আছিল। মিঠাহীৰাৰ মই কাষ্টমাৰ বুলি ভাবিছিলো। মিঠাহীৰাক মই বহুত দিনৰ পৰা তাইৰ ভাইটি মোৰ লগত আগতে মিঠাহীৰা আমাৰ ওপৰত আগতে এটা কেছ দিছিল আৰু এই ঘটনাৰ সময়ত কেছটো চলি আছিল। উক্ত মিৰাহীৰা মোৰ ওপৰত উক্ত কেছৰ সময়ৰ পৰা মিৰাহীৰাৰ লগত আমাৰ শত্ৰুতা চলি আছিল। himself admitted আৰু কোনো মাতবোল নাছিল আৰু মই হীৰাৰ ঘৰত কেতিয়াও যোৱা নাই আৰু হীৰাৰ তাৰ পিছত মোৰ তাত কেতিয়াও অহা নাছিল। And he stated in পানীৰ দৰে বস্তুটো গৰম পানী হয় নে এচিড হয় মই আগতে জনা নাছিলো। হীৰা প্ৰায় 1.5 মিটাৰ মান দূৰৰ পাৰি দিছিল। গ্লাছটোৰ সাইজ পানী খোৱা গ্লাছৰ নিচিনা নহয়। মই তেতিয়া গ্ৰাহক সিদ্ধেশ্বৰ দাসৰ লগত মাছৰ দাৰাম কৰি থকা হেতুকে অমনোযোগী আছিল আৰু আসামী মিৰাহীৰাক চিনি পোৱা নাছিলো।
Sit.
That's it, my lord. Also stated that they have my
That
lord.
can cut the other way also. Okay, fine.
My lord, decisions are there, my lord, where my lord, on the basis of the interested witness and on the
But that
accused-
has not been
acquitted,
established. Okay, fine, ma'am. Victim.
Lord, already, my lord, in case also 17 is in behind the bar. I want
18 years.
18 years, almost 18 years. On so now, my lord, decisions regarding interested witness and animal.
First one
Where
is
from,
for
my lord, the acid has been collected. Acid is not such a my lord, it is available in the market, my lord, readily available in the market. Collected this, who gave it to her, the glass she used.
What is this Motilal for?
Both in both this
Okay. Now, if we don't accept your plea and we say that the conviction is correct, what would be your argument?
conviction
That we have got it. We'll examine. But we come around and say that the conviction is fine. Conviction, prima facie, the court has not committed.
presume, my lord. It is presumed on
Madam,
presumption.
even if-
person cannot
even
be,
if-
my lord. On presumption, a person cannot be, my lord,
This is not
convicted. It must
presumption,
be
this-
established, my lord.
I don't think so.
Only
We are with you on that.
persons, my lord. Only that two
We'll
persons.
hear Mr. Goswami. We'll hear Mr. Goswami.
Only that two persons who
Normal, my
are
lord.
connected, my lord. Though are sorry, related, my lord. Plus, no one has said that Mira had committed the crime. On presumption, my lord.
The reason is Sushil and Meera were so close that even if she covers her face, he knows her.
That evening.
Dark also, my lord.
They'll know each other. Now, madam, if we go against you, what would be your submission? Still, there is a part left. Conviction, I'm against you. Think, we can go against you. What about the sentencing?
45 days. During that period, the right to
Now she is married.
the truth, my lord.
She is married. It's-
There's also stated in her defense witness also that her marriage was fixed.
Fixed.
The deposition of my lord PW2 and PW5, my lord. That is the my lord supported, my lord, though my lord almost supported by the my lord PW4, my lord, because my lord only name, my lord, not mentioned, but my lord the pouring of acid, my lord, and from a close distance, my lord, that is, and he also got injured, my lord, in that,
Even the court witness,
my lord. And my lord, kindly go to my lord PW7 and 8, my lord. There, my lord, PW7 is my lord nearby shopkeeper, PW8 is my lord customer. They have also noticed that my lord, that the victim was lying,
lying down.
lying,
After the
my
incident.
lord, injured
These
condition.
are after the incident.
After the
Yes,
incident.
Post
Af-
incident.
After the incident. But my lord, they have seen my lord the injured victim, my lord. So my lord, and my lord, the CW1 also, my lord, the
Same, same.
acid attack, my lord, that is my lord confirmed, my lord. And my lord may also look at PW10, my lord, IO. He, my lord, categorically said, my lord, that he has found evidence against my lord 2 accused, and that is not challenged, my lord. That is not challenged. And plea of alibi, my lord, that is, as lordship has noticed, my lord, that is not challenged, my lord. These are the things, my lord. And my lord, PW2 and PW5, lord, they are very categorical, my lord. They are
Now,
have
what
a
do you
weight.
say about the changed circumstances? Have moved on. People have moved on. Sushil has also moved on. The lady has also moved on. 2 children.
That aspect is.
Not a thing which can be condoned. But given the delay and the absence of any pre or any past conduct of similar
Yes.
nature,
An
we
innocent-
may consider granting her probation.
Lord, as lordship earlier mentioned that acid attack, my lord, it is very, but same situation also, it is up to your lordship, my lord. 2 kids, that
2 kids,
going kids,
madam has it on record.
my lord.
Okay, we'll not send her to jail.
Obliged, my lord.
Scenery is on legs. Published.
Hmm.
To examine this one, my lord. Is on the basis of medical report, my lord.
Medical report,
Report and PW2, that is the mother of the
Mother's
victim, my
statement.
lord.
Hmm.
Other two PWs, their statement has been corroboration, my lord, in their statement, my lord. Finding out, my lord, I have to page number 28, my lord, that is 330, the statement of the accused, my lord. I'm
Hmm. Hmm.
No, this is the only defense, my lord. His defense not being considered by the trial court, my lord.
That loan part. But there is, when he examined, the cross-examined PW2 on the father, not a single suggestion in this line given. And see, the enmity that they are saying, if it was, they were enemies, regularly, that interaction was there between these two families on a regular basis. So, 4-year-old girl. Yes, Mr. Goswami. Yes, Mr. Burwa.
1 and 2, my lord.
What do you say about the statement of the
Because of the past charge sheet, my lord.
where is the charge framing order?
My lord.
Ms. Ghosh, where is the charge framing order here? So whether this would be, we will have to interfere with this, direct the session court to consider the matter afresh, framing of charge on the fixed date and proceed in the matter. Agreed? We will not pass a big order. We'll say both of you have agreed and this we are passing it. We'll interfere this part of the order framing charge against you. So Bora, that will do. Both of you agree? Hurt Mr. D.
Then there will be stay, my
Okay. What stay? Now I'll direct the trial court to fix a date, issue notices to you, appear. Can you just check up the date and tell me at 2 o'clock? So we'll pass the order. We have one matter at 2 o'clock. Thereafter, we'll take up this. We are sending back the matter. Your only plea was there was no supplementary
Yes,
charge.
there was a past charge.
Done, finished. Rightly so, this court had given you that
For a long
protection.
time that has been filed.
Now,
It's no, nothing in this record, my lord.
fingertips. Hmm.
But I have not found in the record, my lord.
Okay. We'll try after 2 items at 2 o'clock. You have any other matter fixed up? You do it because there is one criminal appeal which I've kept and 2 matters in the top of the list because this matter is after the top of the list. So we'll finish those and
Fine.
come back to it.
No problem. Much obliged.
My lord, this matter was sent
Ms. S.B. Chaudhary, learned counsel for the petitioner, submits that the matter was forwarded to the mediator by this court on for mediation by this court on 27/8/2025. For so, she submits that a mediator has already been appointed in the matter, and the next date fixed is on 25/9/2025. So accordingly, registry to list this matter after 4 weeks along with a report of the mediator. None appears for the petitioner on call. Also, registry to list this matter in after 4 weeks on a date to be fixed by. Oh, that matter. Where is Ms. Ghosh? None appears for the petitioner on call. Registry to list this matter immediately after the ensuing summer vacations. After the summer vacations. No rush now. Puja vacation, sorry.
Item
Yes, Mr. Deori. Uken Singh.
Yes, sir. Convicted.
It will not finish by 1, will it? No. We'll have it. There is some matters listed at 2. After that, we'll take up your matter. Second up.
Six Lordship.
It will after Mr. Deori's matter. But today, it will not go beyond. It will not be carried forward.
8,
Yes.
Wait, please, bro.
Incident is of? Incident is of
2008.
8.
What happened? There were other
That is filed. Case is filed against them. They are absconders. That is filed. What is the error in the learned quotes below?
there is no evidence against. W1 is the
From
was in Bongaigaon. Abir Stan. Rahman and took rupees 13,000 from was given on 20 was informed that on
this, then that PW2's evidence. He says that money was given to Azizul Haq, but money was not given to Azizul Haq. He was there with the other two, Horen Sharma and the other, he was also there. And on 4/4, that is in continuation of 26/4.
an accused was contacted by his maternal uncle Government's maternal uncle. They called them. This accused did not call. There is no evidence that he has done anything. Has taken the money. He's not.
Reported different. But the person who was with him, the witness who was with Jagannath something,
He was not examining.
Jagannath Sarkar was not
He
examined.
was not examined. Nothing. What happened in cross-examination? It is revealed. The answer was written by.
We'll consider it in detail in the second. Provider, the person. What a item number 13 to Matila. Yuri 2. We have 2 items before you. We'll complete that, then come back to you, please.
The heroin were Almira.
In a black bag.
May I take your lordship to pray?
C.
It was initially charged under 21C. I was convicted and sentenced under section 20. Only 40 grams were.
You were sentenced to some 6 months or so. 3 years, 3 years. You want me to look to evidence of?
Evidence of PW3, Your Lordship. Bhajananath Taluk.
That is that land on the
Land.
owner.
They saw me their identity card. In the cross-examination part, Your Lordship may kindly. Third line, Your Lordship. Starts with the main gate. The main gate was locked. Side gate was locked. No. Later, police called me. I saw police brought the. I had not seen police. Established by the prosecution. Bag was recovered from the Almira.
Because the 2 ladies who were accompanying the inspector, they all said that this bag was recovered from the Almira. Your plea was that this Almira, it cannot be from my conscious possession because this is under the exclusive control of my wife. That's the only plea.
And one more thing. But in this case, for going there, Your Lordship, may I
So recovery, there can be nothing.
recovery, nothing can be done.
Recovery is established.
PW 9, which is who. It's in internal page number 3, Your Lordship. PW.
Just a moment. PW?
PW 9. Sorry. PW.
Devodotto.
PW9.
PW9.
Okay.
Lordship. Only one line I will read from page number 3. Exhibit 6. Exhibit 6 is the authority letter issued by A.K. Sharma, DSP.
That did it.
Had done everything. Lordship, may kindly peruse that in later, your Lordship, Exhibit 6. Last page of my paper.
There is a paper book here.
I have been provided with a book.
Oh, you are given special treatment.
No, your Lordship. A book, your Lordship, but this
Oh, they have given you a very special treatment for that, but that treatment is not extended to the court and the prosecution. So we are prejudiced today. That is exhibit.
Exhibit 6, your Lordship. Page 23, your Lordship. Okay, second one.
Exhibit 8,
6, your Lordship.
6. Eight. Exhibit 3 is here, then it becomes exhibit 6, 8. Exhibit 7, no, they have, it's here. They have missed it. They have, while putting it back, they have done it. It's all because of Mr. Dury. He has done it.
May I read, your Lordship? I will-
You can.
It is confidentially learned that one Raju Ali of Adgaon, Guwahati, from a Naga woman of Pili under Bokhisto. The said Raju Ali will collect heroin from the Naga women today in between.
This is issued by that DSP.
By the DSP, your Lordship. And your Lordship may kindly again
That is
Yes.
exhibit 6.
exhibit 6. W9, your Lordship may kindly.
Ah.
6 line from bottom, your Lord. Part of PW9.
PW9.
It's your Lordship.
I can go
I
to
can
any-
go. I can go to any place within 24 hours of the day and for such. No separate permit is required for. Kindly peruse section 40.
it too. . Yes.
I read your lordship. Power to entry search drugs control. If he has reason to believe from given by any person and had taken down or any document or other article which may furnish any illegality acquired property or any acquired property which is liable enter between sunrise and sunset, enter into such and such provided that in respect of a holder of reading it, the next proviso provided further that if such officer has reason to believe that a search for the concealment or evidence or facility for escape of sunset and sunrise after recording the grounds, that particular thing was not.
Say that the that was granted is granted under the first proviso, not under the second proviso.
Because he, after when an officer takes what's ground for his belief, 72 hours send a copy thereof to his list to judge. Was a 9-8 assist. Para, your lordship, 35. Of the nature referred in a register concern before proceeding to clause A to D of section 4. But if the information is received when otherwise, either by and any delay would have should not be feasible or practical. Record the information in writing and in other words, the compliance of writing down the information received would normally precede the search and seizure of the office. That is, after the search, entry and while total non-compliance compliance with section 42. But if the information is where the police all and does not inform the official superior that there is an educator
See how that would be applicable here. Come back to 42.
May I read the proviso part, Your Lordship, first?
Just a moment. The first proviso will have got no application here.
No, no, Your Lordship.
That is in case of respect of a license for manufacturer. So that is not required. Now the second proviso provided further that if such officer has reason to believe that a search warrant authorization cannot be obtained without affording opportunity for the concealment of evidence or facility for the escape of the offender, he may enter and search such building, conveyance enclosed at place at any time between sunset and sunrise after recording the grounds of his belief. He shall within 72 hours. Now here he went there not on his own, he went there with the permission.
When they are with the permission, Your Lordship, entered the premises. That is, he entered the premises because
After sunset.
after sunset, Your Lordship. And thereafter, he should have been
How was this point was taken up before the trial court?
was not taken up before the.
No. There is a finding.
It was there, but in the trial, it was not taken up.
No. Before the court,
Yes, before the trial.
come to page 21. 12. Internal page 12 of the judgment. Just after near the seal, argued, the word argued is there. He further argued. Just there is a seal of the district and session judge.
Further submission, sir.
He further argued. Now, how was it dealt with? Page?
I read, Your Lordship, the learned counsel.
Okay, he went by the letter of the CID. Other, you gave me only one judgment or two judgments?
And there is another judgment, Your Lordship.
Just show me anything on this point. This is a different issue altogether. This is with regard to giving information. What, this is different. Where is the one with, which deals with 41 per se?
Your Lordship, second court holder.
2011,
860 130, Your Lordship.
1,
130, para 11,
130.
130, 130. Carried, Your Lordship. Therefore, clear that the total non-compliance with the provisions of subsection 1 and 2 of section 4, but delayed compliance with the status. We have gone through the evidence of DSP Charanjit Singh did not.
It follows Karnail Singh.
Yes, Your Lordship.
The learned trial court also held that you did not have the officer did not have a proper authorization. You mean to say that that finding on coming on record, so 42 would apply and these two judgments would have the effect of exonerating the app? Yes.
I'm saying
Okay.
section 40.
Goswami, you mean to say that this is a search under 41(2), the last three lines, authorization being there, he does not need not. When there is no authorization, 42 would come into. Okay, done. He says that he can go in anytime, anyhow. Just a moment. Okay. You want me to read the IO statement? PW9. Hmm. Hmm. Yes.
The all part, man.
This is how he was led to Oken Singh. Because first they went with somebody else. That went to another family in the Potang Bazar police station, Potang Bazar Hotel. From there, one Bijoy. From Bijoy to Oken.
That is why section
Super.
42 years. Merciful submission.
This is this is a network. The recovery. Highest recovery was from the appellant, 40 grams. Hmm. Hmm.
And then so far. Minus. Here. It's a one.
Done.
May kindly note this 250 milligram, my lord.
So this is they amalgamated the three recoveries. 40, 10 and sample from the said narcotics drugs were also drawn in said, in 3 packets in duplicate, each 250 at the place of occurrence. At Basista Police Point, that is Raju Ali. Bondona Hotel, that too, husband and wife. And Jotia is the appellant here. So there were 3 because in the FSL report, there are 3 samples. Milligram each. No dispute on that. And all the 3 packets have returned positive. Fine, no dispute. That in your earlier cases, what was there, it is not here. But this is not 3 packets of 40 grams from the Okinsing. This is 40, this is 0.25, 250 milligram each from the 3 recoveries.
Yes.
Then
No, my lord.
250 mg, 40 gram, 4 gram, 250 milli, and 10 gram, 250 milli. 4, 10, 40. This is the 3 recoveries. We are not concerned. You can only say one thing, that 250 milligram, 3 packets also included 40 grams recovery sample, and these 3 packets were received by FSL. No dispute on that. Next. Where are you reading? The further cross. Okay, the body of Subhash Samas. Mr. Puri is also not questioning the recovery. He is questioning the mode of recovery. 42. Okay, fine. No, that the other two lady witnesses also have said this. So he is not saying anything about the recovery. He says that the recovery technically is wrong because you have not complied with 42(2). Okay, fine. Yes,
2023, eight. Hence, the act of paragraph 5 of the said judgment.
this is referring to section 52.
52A, Your Lordship.
So it will be 52(3) here. Every person arrested and article seized under subsection 2 of section 41, section 42, 43, 44 shall be forwarded without unnecessary to the officer in charge of the nearest or the officer empowered under section 50. The authority or officer to whom any article is forwarded shall with all convenient dispatch take such measures as according to law to such person or article. What is 52?
A, Your Lordship.
53.
52A is it.
A, okay. The central government having regard. This is disposal of that narcotic
However,
substance.
it clear.
When was this offense committed? 2000?
2000, Your Lordship.
2000. No, that again, I think is after the amendment. There was an amendment. If we can come to
A was inserted in the year 1980.
No. That was again amended. 2014, it was again amended. Before that, one read as the central government having regard to the so-and-so, specify that so-and-so class of so-and-so, as soon as may be after their seizure be disposed of by such officer in such manner that the government may from time to time determine after following the procedure prescribed specified, hereinafter specified.
Second part, you will see close.
Where any, now 3 was again substituted. Takes drugs and psycho-controlled substance and forwarded so-and-so, such.
Amended, Your Lordship.
So the authorized officer would be it would be permissible for him to draw samples in presence of a magistrate. Now, who is this magistrate here? No. In 52(2), is it an executive magistrate?
Executive magistrate.
Is there any notification in the state that that power has been granted to the police officers also? That executive magistrate's power can be granted, conferred. Is it being conferred to any authority here? Where is the seizure memo? We'll come to you. Come to you. And let this court also understand, learn something. Exhibit 10. Exhibit 3. 3A, Teaser list. No, thereafter he immediately, we come to an exhibit 8. He has forwarded that to the officer in charge. Huh? Huh. Okay. Your case is that 52A has been violated. In addition to violation of 42(2). Is this point taken up before the trial court?
Point in my sport submission.
No, it's not taken up. Okay, what is your reply to this, Mr.?
To refer to the section, why?
Hmm. Ganja and all. Okay, this is for destruction after the inventory is prepared. Okay.
Nineteen 73.
Got it. Hut, Mr. Anything more, Mr. Dury?
No.
Hut, Mr. T. Dury, learned counsel for the petitioner. Ah. Hmm. Give me the citation. Party's name? Civil appeal? 55? Arivane Ulawai to Supreme Court. 2004. Ah. One? One two one two zero oblique 20. NCB? Spelling? AASHI? Palm Dip, right. Just a second. Two 2024 SCC online 3848.
Error 39.
Sarah? Does it start? Upshot of the above discussion. The purpose of insertion of so and so, laying down the procedure for disposal, so early disposal, so and so. Okay. Done. That's just, as you said, it is for the convenience of the trial that this provision is there. So if there is 100 kilo destroyed, keep the inventory ready.
But Your Lordship, this is
Okay. Mr. T. Dury, learned additional, the learned amicus curiae. After taking this court through the evidences brought on record by the prosecution witnesses, has referred to the evidence adduced by the investigating officer, PW9. So, now I'll want you that book. But, this is now our property. You take it back after the judgment is delivered. PW9. More particularly to his cross, wherein he had deposed to the effect that, basing on the authorization given to him by the DSP, he can go to any place within 24 hours of the day and can also effect such even at night hours. So, Mr. Dury, by referring to the provisions of section 42(2) of the NDPS Act 1985, more particularly the second proviso thereto, submits that for effecting a search of any building, conveyance or enclosed place at any time between sunset and sunrise, there has to be a specific authorization to that effect obtained. However, if such authorization cannot be obtained without affording opportunity for the concealment of evidence or facility for the escape of an offender, the officer can carry out that search after between sunset and sunrise. However, in terms of the provisions of 42(1), in terms of 42(2), he has to forward information about the same to his next immediate official superior officer. Mr. Deori submits that the PW9 has not made any such report after carrying out the search and seizure in the rented house of the appellant, which admittedly was so carried out after the sunset. In this connection, he relies upon the decision of the Honorable Supreme Court in the case of Karnail Singh versus State of Haryana, reported in 2009, bracketed 8 SCC 539. Para 35, and the decision of the Honorable Supreme Court in Simranjit Simarnjit Singh versus State of Punjab, reported in 2023 at a gap taken as 0, Supreme bracketed SC, bracket over, Supreme to bracket SC to bracket of it 658. Also, Mr. Deori has thereafter submitted that the seizure so made by the seizure being made, Mr. Deori, if something is to be corrected, just tell me that. Mr. Deori has further submitted that the seizure being made by PW9, he was required to follow the procedure as mandated under Section 52A. Mr. Deori submits that provisions of subsection 2 of Section 52A mandates a particular procedure to be followed even for taking samples, for drawing samples, which sample has to be drawn in presence of a magistrate. So, he submits that in the present case, the PW9 had taken the samples at the place of seizure itself without the same being referred to, without the same being so taken in presence of the magistrate authorized in this connection. Accordingly, he submits that the samples not having been taken in connoissance with the provisions of Section 52A, the subsequent steps taken thereon, including the offense report filed in the matter, after the sample had was returned as positive by the FSL authorities, cannot be sustained, and the penalty imposed and the punishment imposed upon the petitioner herein, appellant herein, would mandate conviction, and sentencing of the appellant herein would mandate an interference from this court. This is your submission. Nothing more. This too. Also, per contra, Mr. MP Goswami, learned counsel for the respondent, for the state respondent, has countered the submissions of Mr. T. Deori pertaining to Section 42(2) by contending that the said provision would come into operation only when a seizure, such or seizure is made without warrant or authorization. By referring to the evidence of PW9 and more particularly Exhibit 6, Mr. Goswami submits that the PW9 had proceeded to carry out the search and seizure involved in the matter only after being authorized by the DSP AK Singh, AK Sharma. Oh, it's 6 is here. Now it is with me, no? If by A.K. Sharma, APS, Deputy Superintendent of Police, CID, Assam. Also, accordingly, he submits that the same would be covered by the provisions of subsection 2 of section 41. And accordingly, the PW9 was authorized to carry out the search of such a building, carry out search of a building, conveyance or place, whether by day or by night, or himself arrest such persons or such a building, conveyance or place. Accordingly, he submits that the present case, the provisions of section 42, subsection 2/41 of the NDPS Act being applicable, the decisions relied upon by the learned amicus curiae would have got no application in the matter, and the search and seizure made by the PW9 cannot be questioned on the grounds so projected. So, with regard to the contention raised by the learned amicus curiae with pertaining to the steps taken by PW9 after the narcotic substance was seized from the house of the appellant herein, and the issue of non-compliance of the provisions of section 52A, he submits that the same would not mandate a consideration inasmuch as the said provisions that the provisions of section 52A applies only in the case of disposal of seized narcotic drugs and psychotropic substances. He submits that the said aspect of the matter would be clear on perusal of subsection 4 of section 52A, which mandates that notwithstanding anything contained in the Indian Evidence Act 1872 or the CRPC, every court trying an offence under this act shall treat the inventory, the photographs of narcotic drugs, psychotropic substances, controlled substances and conveyances, and any list of samples drawn under subsection 2 and certified by the magistrate as primary evidence in respect of the offence. Mr. Goswami submits that in the present case, the sample, the drug seized being only of 40 grams, there being no hindrance in producing the same at the time of the trial, the preparation of the inventory as contemplated under 52A would not be called for, and the same would not be fatal to the prosecution's case of the prosecution. In this connection, he relies upon the decision of the Honorable Supreme Court in the case of NCP versus Kaship, reported in 2024 SSC Online SC 3848, more particularly para 50.4 thereof, which lays down that which mandates that subsection 2 of section 52A only lays down the procedure as contemplated in subsection 1 thereof, and any lapse or delayed compliance thereof would be a mere procedural irregularity and would not entitle the accused to be released on bail nor vitiate the trial on that ground alone. So he further, it is further highlighted that any lapse or delay in compliance with section 52A by itself would neither vitiate the trial nor would entitle the accused to be released. However, the court will have to consider other circumstances and the other primary evidence collected during the course of an investigation, as also the statutory presumption permissible under section 54 of the NDPS Act. Oh, I'm coming to that. Also, Mr. Goswami submits that in terms of section 54 of the NDPS Act 1985, the drug in question having admittedly been recovered from the conscious position of the appellant herein, comma, he has not advanced any. He had not brought on record any evidence to dispel the presumption with regard to the possession of the same. He submits that the plea taken by the accused during his deposition, during his examination under section 1313 is to the effect that the Almirah from wherein the said drug was seized was in the exclusive custody. That is, I think, the word used. Where is Oken Singh, Ujjoti Hazorik? Question number was 10. No, there is a categorical thing somewhere. Control of his wife will equate it. Dismissed. But we appreciate what you have done. It's a learning experience.
Deeply obliged.
That will not have application here. Cannot be. That will not have application. 52A, we have got it. Here it will have no application. No, don't. I have understood something. Let me remain in that.
Highly obliged.
Thank you, Mr. My appreciation, we will record it in our order for your services.
Highly obliged, Your Lordship.
Yes. Yes.
This is what happened? What that was taken by H. Sharma, alias
Elias Horen Sharma.
my lord. His maternal uncle Babulal Mondal had introduced
Now, the accused who had gone under trial, your case would be that Azizul is one of them. But on 26/3/2008, the incident that was forming, there is no material connecting him with that. Only the material with regard to evidence of PW2. But on the day 4/4, when he had gone to collect the balance amount, he was apprehended.
what happened? He has called.
Naturally, he had called because he wanted the appointment order.
Government has called.
He wanted the appointment order. The appointment order was to be given by you. You dilly-dallied. You called up one Rahman.
Were involved, not me, because the medical certificate was
What is your penalty? What is suffered 2 months? Under section 420.
had already spent 2
Already. Okay. To the extent he has already undergone. That we'll mention. Huh? Uh, Is this the case wherein a mention was made before the registry that he has already completed his sentence? Is this the matter? You made a request before the registry? No, not this. Okay. Okay. You're Mr. A. Alam. And we record your statement to the effect that you have completed 2 months. When were you arrested? That will clear it. And when were you granted bail? Why don't you have these records? You can have these records, Mr.
He was
Alam.
arrested on 5/4.
Can have these records. We can just confirm. He was arrested on 5/4.
5/4/008.
And released on bail.
Then on 4/6.
So that is roughly 2 months. Can you just mark that? The records you have, just mark that person for me. So the period undergone, disposed of. There is a stay order here. Stay order. No problem. Whether mechanical failure before the accident or after the accident. That then how did you go and stop your vehicle in the premises of your the hospital?
That effect, there is no evidence.
Somebody pushed you. You will have to satisfy us because that nobody had seen you ran away. You hit him and you ran away. Now, how did you get this vehicle parked exactly in the garage of the how? Just satisfy me that. CHC. So you after you had hit the man, hitting is proved that you had this accident is established because the damage to the front portion is there. Now, after the accident, you proceeded, you did not stop, you ran away. Huh? But this vehicle was found when the man was taken to the hospital to be standing in the front of the hospital, maybe in some garage or something there. How did you, when you had a mechanic, when your brake was failed and you were going in such high speed, how did you reduce your speed? Now we want to know because sometimes it may happen to us also. So we have that experience from you. The accident is not denied by you. Denied by you, 313, it's not denied. So tell me one thing. If the accident, how did you go and stop your car?
The record, my lord, to that effect, my lord. Of the record, I may was putting one here, my lord. He may go, my lord, by using his brakes also, my lord. Because effort is there because exhibit 2 is the, my lord.
Because
case map.
there is nothing shown here, no material, that there were also skid marks at that hospital. Here the skid mark shows that you had braked. You had braked.
That effort of, my lord, effort by the driver to have that accident avoided, my lord.
What is the penalty? What is the
Penalty,
punishment?
Penalty, my lord, 2 years, my lord. 6 months for, my lord, 279 and fine 1,000 and 4, my lord, 2 years and 5,000, my lord. My lord, some evidence of all the.
How old are you now?
Now, my lord, at that time he is 30, my lord. Now he is at that time maybe he will be around 40, but 45.
Date of the incident?
Date of incident, my lord, is 30/12, my lord, 2010, my lord.
Why did you not? You are an ambulance driver. You should have stopped. You did not stop.
But if you go by the evidence of IO, my lord, it is evident, my lord, that it was immediate. I'll just that part, my lord. On the other hand, 9:30 p.m. on the day of incident on 30/12/2010, Dr. Kiparnath Morang from Junai CAC also in the police station for phone about the accident. It was immediately informed, my lord. Maybe, my lord, immediately informed. FIR was lodged on
That
the
man's life may have been saved if you had taken him in the
yeah, in the evidence, my lord. He was the evidence, my lord. I have translated.
'79 30. Mr. Sharma, 279 6 months, or with fine, or both. 354 304A is 2 years or with fine. What has happened has happened. After 12 years, we are not sending him back to jail. Limited to the fine. Sentencing done away with. Anything more required?
What judgment of 3 was the judgment is, my lord. If lordship, my paragraph, my lord,
Oh, you want it to be on merits?
No, no,
Okay,
no,
we
no,
will
no, no,
consider
no,
on
no.
merits then. No, fine. No?
I'm
You,
not a
nobody should go.
I'm just placing your lordship for your lordship perusal.
Please. I love it. What is it?
So, my lord, my lord, para 12, 13, 14 of this GLT, my lord, 52 GLT 274, my lord. Five GLT 274. Two recent judgment of
My Lord Justice Chaudhry's.
789, my lord.
No, there is evidence in your case that it was a rash and negligent driving. The respondents have said. The PWs have said.
By his evidence, I have just translated, my lord. And if you go by the evidence, my lord, the cross-examination part, he says, my lord, the lordship may kindly third page, my lord. The last 4 line, my lord. I did not witness the vehicle knocking the person down. I did not notice whether the victim was in the right side or the wrong side at the time of accident. I did not witness the event leading to the accident, so I cannot say to certain whose fault it is. That day, the victim consumed a small amount of intoxication.
Come to the chief.
Yes, chief, my lord.
1, 2, 3, 4, 5, 6 lines. Then as the individual who had died in the accident was going through a so-and-so, a medical ambulance which was coming from the opposite direction hit him. This much he did not see, let's say. But the rest one. And pushed him, you have used the word pushed him. It also dragged him for some considerable distance.
Here, my lord.
That is so, that accident is seen. The vehicle was at high speed. A loud sound emitted when the vehicle hit him. After causing the accident, the vehicle did not stop. So the impact of the accident he did not see because he was driving a bicycle ahead. The victim was behind him. So he did not see, but immediately when the sound was there, he saw. And he saw the victim being dragged. Then. Here the evidence was not there, but that the petitioner, the person involved was driving the vehicle. On that counts, the court said nothing doing. What is the next judgment? Justice Kaushik Goswami. Okay. Oh, 425. And Anandi Rai. So here also the driver was not identified. So the court went in. So now that we will have to convict you, that means 379, 279 and
I,
because the driver here is identified. Mr. Alam, the driver is identified here. In these cases, the driver is not identified. No, we can't. When the law is that driver not identified, you must be released. What the driver is identified, you must be put behind. So, go and surrender.
I've just given for a lottery.
Mr. Sharma? Comment it on merit. The evidences are there. Okay. Released him, only fine. Conviction would be there. Yes. Want to compromise. Where is the lady who made that submission?
Trial court, my lord, petition.
You could have filed a petition before this court. Where is that madam who was here? The respondent. No, there was a representation. Oh, that is item number 12. Okay. Oh, this is that village. 5% sitting, one going, being called, then he was hit. Ah, okay. Ah, what is the error?
Identity, my lord.
Gupta, these are villages. They don't require light for the identification. They can identify by sound. Huh?
Calling is not denied.
Calling is not denied, but the lady, Promila, she came informant. When other two are very aged people. They are not used. When she came out, she saw him running, and that witness, that evidence has not been dislodged. Feet, but she identified you that you had a torch in your hand and a dao. And the victim clearly identifies you. But then, and that is corroborated by P1 and very badly beaten. I think there are at least 6 injuries. And all the 6 have been verified, corroborated by the medical evidence. So, when is the incident? Date of the incident? 11 years only. Oh, 2006. 19 years. Only. The penalty is yes, Mr. Goswami. Four teeth had come out. See, all accepted, all accepted. But if you come to the CJM's order, there was a petition filed. It is at
17, my lord.
17. Type copy, para 16. Para 16. There was a petition filed that they had compromised the matter, but it's not a no. 320 will not have an application because it's not a compoundable offense. If they had come up before this court, maybe this court could have entertained that application. In this view of the matter, fit case to give probation. Disposed of probation, nothing more. Conviction maintained. Yes. Obliged. Ah. Yes, madam. So you want this matter to be now, you have got no objection. Huh? Why did you institute these proceedings? Whole state machinery got involved. We'll acquit him. But at the cost of how much? Maybe one sub-inspector, two constables, one lower court judge taking up the matter. Now the High Court is taking up this matter from 13. You're occupying space in our disposal, in our pending section. So altogether, how much cost? If you want that calculated, we have the Standing Council of High Court also here. We can ask him to make that calculation. Yes. On humanitarian ground. What is the meaning of humanitarian ground? Oh, neighbor, but when you hit him, you did not feel that humanitarian feeling in you.
1 year.
Oh, now you go behind the bars, that humanitarian feeling will more grow. It will be better for the society. Yes, why do you want to? Why you made that submission? Neighbors, you have forgiven him.
I have some very.
Want to argue on merits? We'll be clear.
No, my lord.
It will be a clear acquittal then. Yes, Mr. Soma. Now the victim says, what is your name, madam? You're a Wakalatnama holder here? Huh? Where is your, when did you file your Wakalatnama? Today. What is your name, madam? Chamber mates.
There is compromise, my lord.
Chamber mates.
They are not family, my lord.
Chamber mates. It looks very bad, Mr. Barbie. Does not look nice. That is why in the morning when that prayer was made, the reaction from this court. I thought you would understand, but you have not understood. Okay, make on merits. Let us hear the matter on merits. Mr. Sharma, we'll hear the matter on merits. Yes. Madam, your prayer is rejected. Compromise, we are not concerned. We are concerned with the merit. You have told them very well. So you have told them that I'm not bound. Now, if I pass that order, they will think that you have made a wrong submission. How can I put you in bad light? I can't put you in bad light. How can I put you in bad? Mr. Barbhaiya is a medium. You are medium senior, I'll say. Such a long practice. You told them that this court will not do that. If I do that, what will be your image before those people?
Consider, my lord.
You said court will not do.
Actually, there is a bar, my lord, 220, 26, my lord, is.
320 is a bar for the trial court. See the case of Gyan Singh and all, there is a series of cases wherein the power is with this court.
Yes, my lord.
You could have come up with a
Consider,
petition.
Lordship may
Okay, what is your ground?
ground, my lord, Lordship, in this case, my lord, first ground, my lord, there in this case, my lord, admittedly, the basis of my lord, sole, my lord, evidence.
What is the law with regard to the appreciation of victim evidence?
Yes, my lord. Sole convict, if, my lord,
Injured victim.
will, my lord, that can be.
So anything here which will render it unbelievable.
Then, my lord,
Because see, he was coming back from the mosque when he was attacked.
very pious.
So,
Here, my lord,
and this is a revision petition. This court will not reappreciate the evidence. Show me any error. Otherwise, we are
error, my lord,
upholding.
326, my lord. For conviction under, my lord,
Come on, tell me what it is. 5 more minutes.
I beg to, my lord, rely.
Sure.
What time, my lord, I prepare.
That is the beauty of Mr. Barbhaiya. Yes, what is the decision?
Memo of appeal, lordship, kindly able- findings of the code. Paragraph, my lord, before going to the judgment, my lord. Page, my lord, 14.
Hmm.
Last part, my lord.
Hmm.
Admittedly, the PW2 is not supported by any of the prosecution. However, the version of PW1 shows that he is the accused, Tajuddin. But may I clarify, my lord, PW1 is, my lord, informant.
PW2 is the victim.
Tajuddin and Moinuddin are running towards, but in the said aspect, the PW2 head has not corroborated the version of PW1. Moreover, at night, the PW1 never stated that by which identify the running towards different directions from the place of occurrence. As such, the evidence rendered by PW1 as regards to the accused Rajuddin and Moinuddin. Rajuddin, my lord, other are acquitted, my lord. Rajuddin and
These
Moinuddin.
are your submissions which have been recorded by the trial court. This is not the conclusions of the trial court.
Admitted this is
That,
observation of the
okay, we'll deal with it.
that such evidence of tendered PW1 as regards to the accused Riazuddin and Moinuddin shows lack of confidence to rely upon. So far as the evidence of PW2 is concerned, he is not corroborated by any prosecution.
This is the submissions. Submissions. Not the finding. Finding you will find
Yes,
in page 16, second paragraph onwards.
yes, Lord.
Having relied upon the above case law, laid down so-and-so, sole testimony of so-and-so as evidence to discard the evidence on any reason. PWT never disclosed the means by which he could identify the accused at night when the visibility was poor. In this context, it appears from the evidence had faced the abuse of verbal abuse was there. Riazuddin had to scuffle with the said accused for a long time. As such, there was scope for PW2 to come close to the accused to identify him not only of his face but also of his voice as a co-villager. Since so-and-so were known to each other, it was not difficult for the PW to identify his voice and subsequently identified him during the scuffle with the accused so-and-so. Hence, no doubt can be attributed as regards identity of accused so-and-so. However, the evidence of so-and-so is shaken by his own contradiction of the statement as regards the implication of accused Moinuddin and Tajuddin, for which it casts a doubt on the version of so-and-so if he could identify so-and-so. Apparently, PW2 confirms accused caused a doublo on the name so-and-so, so-and-so, so-and-so. So, with regard to the offense of you and the scuffle between you and the victim, the court has said that is why 326. Ingredients of 326.
Here, my lord, this aspect is clear, my lord. There is no other evidence, my lord, only. Now, my lord, first judgment, my lord, I am relying, my lord, I have given above, my lord. This is paragraph 11 and 14, my lord. 11 to 14, my lord. This is in contradiction, my lord. Yes, my lord, what stated in the FIR and what stated before the police and what
Okay, then next. 2009, Bukul Rani Das.
I, my lord, need to read out this paragraph, my lord. In
Okay.
This case.
Heard Mr. A.M. Burmia, Lana Counsel for the petitioner. The hearing remains conclusive. Register to list this matter again on Friday as a top of the list item. Yes, Mr. Das.
Oblige, my lord.
Now this court has forgotten everything. You only knows 326, 324, 325, 354.
Diversity is always required.
A lot to learn. There is much to learn.
That's wrong.
It's a learning experience every day. So, Ms. Gain, anything more to be added? We will decide the first case, if possible, before the vacations. The second case we have already expressed that we are not going to deal with the life of a girl in this manner, permit the indulgence with a girl in this manner. So both we will send it back. She is in now class 9. Another year. We'll also want the parents as well as the girl to be working or to be conducting herself strictly in accordance with the norms of the school. But this judgment, I'm not sure whether I can deliver it before the vacations because of my criminal bench. The earlier case we have gone through, we have come to a conclusion that the thing is not proper. The materials that are there are contradictory. Take him back and wait for the day when he makes a further misconduct. Go against him then. The second case. Hmm. Huh. Hmm. That's why I asked you whether you can go. Huh? No need. No need. We are not going into that. We only have seen, we are not going into that. Okay, sir. Mr. Das, both of you, with due excuse from this court, I don't know whether I can deliver it before the vacations, but I'll try. Otherwise, immediately on reopening. Immediately on reopening would be after 16th. Because till 12th, we have our hands are full. 13th, the court is opening. 13, 14, I'll do it. 16th, I'll deliver it. October. Okay. Okay. Had the Learning Council for the parties at length, hearing concluded Duta matter day. Registry to list this matter on 22/10/2024 for delivery of orders. Edna bele ekuna rahil.
Much.
For you, fine. Late dinner, late lunch, or early dinner time is there.
That's left me. Much of late.
Heard Mr. D. Bora, Learned Counsel for the petitioner. Also heard Ms. D. Ghosh, Learned Counsel, appearing for the respondent number 2. 1 and 2. No, 2. And Mr. Also heard Mr. MP Goswami, Learned Additional Public Prosecutor, appearing for the respondent number 1. The petitioner had instituted the present criminal petition assailing an order dated 22/8/2019 passed by the Learned Additional Session Judge number 2, Kamrup Metro,